Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so this is a Diddy update. It's been a while since I think it's been a while since I did an update on him. But I believe the last we spoke, we were talking about how he was pulling the race card, saying that he was the only individual that was being tried under a particular act for count three of the superseding indictment, which we just know was pretty much outrageous. And the government's like, no, we're not falling for that. They filed their opposition to that, and we're going to get into that in a second. Um, Now today, what time is it? It's 12:23 p.m. my time. I'm Central Standard Time. So both parties should have met and conferred and filed a joint letter for any matters that needed to be addressed at tomorrow's conference, which will be held at 2 p.m. Eastern Standard Time. I didn't see any updates on the docket, not saying that nothing has been filed. It probably will take a while for it to be uploaded through Pacer and actually docketed by the clerk, so on and so forth. So, tomorrow they are going to speak about the superseding indictment that was submitted to add certain things into it that Diddy found to be obviously, in his case, he just felt like he's being picked on because of the color of his skin, and that is not correct. Has been out here doing things that he should have not been doing. Now he's being implicated in other areas. Kirk Burrows came out with his lawsuit against not only Diddy but Diddy's mother. But in Diddy's case, Diddy did some very, very cruel things to these victims. Thus, the reason why the superseding indictment was updated. Now, get into the government's opposition to Diddy's response to dismiss count three of the superseding indictment. Again, they're going to be talking about this tomorrow, but to kind of see where everybody is at, let's look at what the government's opposition is, so that way we have a better understanding what will be discussed tomorrow at the hearing. So it says the government respectfully submits this memorandum of law in opposition to defendant Sean Combs' motion to dismiss count three of the superseding indictment in this case. Offering no more than his say so, the defendant makes the outrageous and illogical claim that federal prosecutors brought one and only one of the three charges against him on account of his race. Because Diddy, why are you just trying to get a motion to dismiss count three and not the other counts for the X trafficking? Can we make this make sense? Or the RICO? It doesn't make sense at all. Tellingly, the motion fails to mention that the other counts of the very same indictment allege that the defendant engaged in horrific and repeated acts of violence and actual coercion, harming multiple victims over the course of multiple years. The context alone defeats the motion. Count three charges conduct overlapping and intertwined with the years of violence, abuse, and exploitation alleged in counts one and two. The defendant's baseless accusations that he singled out on account of his race are false and fall far short of the rigorous standard required to make out a prima facie case of selective prosecution. Race did not factor in any way the defendant's charges. On the contrary, as set forth in the indictment, the defendant was charged solely because of his own violent and abusive and criminal conduct. The motion to dismiss count three should be denied. On January 30th, 2025, a grand jury in this district returned indictment charging the defendant in three counts. Count one charges the defendant with participating in a racketeering conspiracy between in or about 2004 and 2024 in violation of the Title 18 of the United States Code. Among other things, count one alleges that the defendant coerced three female victims identified in the indictment as victim one, victim two, and victim three to engage in commercial X acts. The indictment alleges that some of the victims were coerced to engage in commercial X acts that sometimes lasted multiple days and often involved multiple male commercial X workers. Count two charges the defendant with X trafficking victim one by force, fraud, and coercion between in or about 2009 and 2018, again, a violation of Title 18 of the United States Code, Section 1591. Count three charges the defendant with transporting multiple individuals, including the same ex trafficking victims identified in count one, victim two, victim three, and male commercial ex workers interstate for purposes of engaging in uh, prostitution between in or about 2009 and 2024, which is a violation of Title 18, United States Code, Section 2421A. What's very, very weird, I don't know the angle or the path that Mark Agnafilio and the rest of the attorney team is going for, because why would you just only move to dismiss the transportation count and not also the RICO count and the X traffic count? It does not make sense. It doesn't make sense at all. So it's like you're saying, I did those other things, but this right here, I didn't transport. Really? The indictment provides detailed factual allegations describing the defendant's years long pattern of criminal conduct involving the abuse, sexual exploitation of multiple victims that conducted included a I'm sorry, that conduct included a persistent and pervasive pattern of abuse towards women, including verbal, emotional, physical, and sexual abuse that spanned years. The indictment describes the transportation of both women and commercial ex workers has as intertwined with the defendant's coercion of women to participate in orchestrated performances of sexual activity by distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same, and using intimidation and violence. Because I do believe that there were John Does that actually came out and sued him that were actually commercial ex workers. The defendant's violence included striking, punching, dragging, throwing objects at, and kicking women on numerous occasions over multiple years. The defendant used his vast resources and business empire to carry out, facilitate, and cover up his acts of violence, abuse, and commercial acts, enabling the defendant to continue this criminal conduct for years. Mind you, going back to the Cassie video that we seen, for him to have paid, I don't know how much he paid. I don't know if it was $50,000 or $100,000 to the hotel staff to have them release and give him those tapes. How did you pay for it? Did you pull it out the Bad Boy Entertainment account? Because that's what Kirk Burrows says that you did, just like with the incident with Tupac and Biggie. But carry on. As alleged in the indictment, this criminal activity includes violations of multiple federal laws, including forced labor in violation of Title 18, United States Code, Section 1589, X trafficking in violation of the same Title 18, Section 1591, the transportation to engage in prostitution in violation in Section 2421. These allegations are included both in the racketeering conspiracy charged in count one as racketeering activity and in the statute offenses charges in count two, X trafficking, and three, transportation to include or engage in prostitution. The indictment thus makes clear the transportation alleged in count three served the defendant's abuse of victims. The count alleges that the defendant transported the same victims identified in earlier paragraphs as victims of abuse. The count also alleges that the defendant transported commercial ex workers which corresponds to the allegation in earlier paragraphs that the defendant coerced female victims to engage in sexual activity with male commercial ex workers. All three counts of the indictment, thus, on their face, charge a common course of conduct arising out of the defendant's abuse and sexual exploitation of multiple victims. Here's where the law applies. A defendant challenging the government's decision to prosecute him bears a heavy burden. In United States versus Armstrong, federal prosecutors retain broad discretion to enforce the national criminal laws. As a result, the presumption of regularity supports the prosecutorial decisions, and in the absence of clear evidence to the contrary, courts presume that they have properly discharged their official duties. Importantly, a selective prosecution claim is not a defense on the merits to a criminal charge itself, but an independent assertion that the prosecutor has brought the charge for reasons forbidden by the Constitution. To establish a claim of selective prosecution, a defendant must present clear evidence that the decision to prosecute not only one had a discriminatory effect, but two also motivated by discriminatory purposes. So, what evidence do you have that they singled you out to charge you with this particular count? What evidence do you have because of your skin color? They just decided to pick you and only you to apply this charge to. When articulating this test, the Supreme Court has taken great pains to explain that the standard to establish selective prosecution is a demanding one. With respect to the first of the two required prongs, the term discriminatory effect, a defendant must establish that others similarly situated have not generally been proceeded against because of the conduct of the type forming the basis of the charge against the defendant, and that the defendant has been singled out in his case. With respect to the second of the two required prongs, discriminatory purpose, a defendant must establish that the government's selection of the defendant for prosecution has been invidious or in bad faith, based upon the such impermissible considerations as race, religion, or the desire to prevent his exercise of constitutional rights. This means more than the government acted with the awareness of consequences, whether it must have selected or reaffirmed a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon an identifiable group. Where a defendant has not shown that the government prosecuted him because of his protected status or conduct, his claim fails. Consistent with the presumption of regularity, the Supreme Court has explained that the showing necessary to obtain discovery in support of selective prosecution claim should itself be a significant barrier. A defendant must meet rigorous standard for discovery in aid of such a claim. Because the decision to prosecute is particularly ill suited to judicial review, and examining the basis of a prosecution delays the criminal proceeding, threatens to chill law enforcement by subjecting the prosecutor's motives and decision making to outside inquiry, and may undermine prosecutorial effectiveness by revealing the government's enforcement policy. To obtain discovery, a defendant accordingly must show some evidence of both discriminatory effect and discriminatory intent. Mere assertions and generalized pro offers on information and belief are insufficient to meet this burden. I'm very, very curious as to what evidence Mark Agnafilio is going to show tomorrow that says my client was singled out and had this charge pinned on him because he is black. Here's the government argument. Diddy's motion to dismiss fails to meet either prong of the required standard to support a claim of selective prosecution. The defendant spills much ink detailing the origins of the statute charged in count 3, but he cites no law indicating that the legislative history of a statute has any bearing on either prong of the selective prosecution claim, and he makes no attempt to connect that history to the applicable test. Stripped of its overheated rhetoric, the motion presents neither evidence that other similarly situated individuals were not prosecuted, nor evidence that the prosecution was undertaken in bad faith. That is because the defendant's theory of selective prosecution has no basis in reality. Race played no role whatsoever in the decision to seek the charges contained in the indictment, which instead stemmed from the defendant's decades of criminal conduct. Because the defendant offers nothing more than conjecture to suggest otherwise, the motion should be denied. In other words, the government, the prosecution, charged him with the transportation charge because of what Diddy has done over the years. They did not charge him because he was black. They didn't single him out because he was black. This is crazy. Um, so going into death, this really just kind of further explains the government's position as to, okay, did he show no did he show no proof? Mark Agnafilio, to be a great defense attorney, didn't provide any type of proof. Y'all stated that no other individual who did the same things that Diddy did were not charged. You didn't show any proof of that. The defendant fails to show that similarly situated individuals were not prosecuted. With respect to the first required prong, the defendant must show evidence that others similarly situated have not generally been proceeded against because of the conduct of the type of forming the basis of the charges against them. A similarly situated offender is one outside the protected class who has committed roughly the same crime under roughly the same circumstances, but against whom the law has not been enforced. Here, to allege discriminatory effect, the defendant relies on three examples taken from media articles: Elliot Spitzer, Jerry Falwell, and an unnamed client of the escort service the defendant used at times in connection with some of his charged conduct. As an initial matter, none of these individuals is similarly situated to the defendant. The motion misleadingly suggests that anyone who has ever hired an escort is similarly situated to the defendant. But the characterization ignores the aggravating factors presented in defendant's case that are not present in the mere hiring of an escort. And the footnote reads, for purposes of this opposition, the government uses escort interchangeably with commercial ex worker, the term used in the indictment, but notes that not all of the male individuals who were allegedly paid by the defendant to engage in commercial ex work for the escort services specified in the defendant's motion. First, the the defendant violated the Mann Act. In the course of ex trafficking multiple victims through force, fraud, and coercion, the indictment allegations that defendant coerced multiple victims into commercial ex acts, including the male escorts who are the subject of count 3, set the defendant in stark contrast to the examples he cites in his motion. There is not a hint of trafficking or coercion raised in any media coverage the defendant cites regarding Spitzer, Farewell, or Falwell, or the other clients of the escort services the defendants use. The absence of trafficking allegations similar to those against the defendant here defeats any suggestion that those three examples represent similarly situated individuals. So, what Mark Agnifilio did was he mentioned Spitzer, he mentioned Falwell, and another client, and he's saying that he's trying to throw trafficking allegations on them. He's trying to throw He's trying to say that these individuals did the same exact thing that Diddy did, but they didn't get prosecuted or charged with what Diddy was charged. But there's no proof of that. There has been no trafficking allegations against Spitzer, Falwell, or any other escorts in that particular company. Second, the defendant carried out the transportation of victims and used force, fraud, and coercion to cause those victims to engage in commercial X acts as part of a broader pattern of racketeering activity. The Mann Act, and remember this is the what they call it, the White Trafficking Act, something like that, which is now known as the Mann Act. The Mann Act allegations stand together with other racketeering predicates, including not only X trafficking, but also arson, narcotics distribution, bribery, and obstruction. All of this conduct, which was overlapping and pervasive, furthered the twin goals of feeding the defendant's personal desires while also protecting and even building his reputation. The defendant used his wealth and power to build an enterprise characterized by violence against victims, employees, and rivals alike. And he used the same enterprise to fund the transportation of victims and escorts in violation of the Mann Act. Nothing in the motion suggests that Spitzer, Falwell, and the other clients of the escort services transported escorts as a part of a pattern of racketeering activity, or they committed any other crimes whatsoever during the same period when they engaged in commercial X. The distinction further widens the already vast distance between the defendant's conduct and the examples that he raised in his motion. Third, the motion conveniently ignores the allegation that the defendant violated the Mann Act not only by transporting male escorts, but also by transporting three victims of trafficking. Examples of other individuals who have paid escorts but were not involved in the transportation of victims of trafficking are thus inapt. Count 3 charges the defendant with transporting victim 1, victim 2, and victim 3, as well as male escorts for the purpose of commercial X acts. You can't do that. Whether you say that it was consensual or not, you cannot be transporting from one state to another. That is considered trafficking. None of the examples cited in the motion involved the transportation of victims of coerced commercial X in addition to the transportation of escorts, revealing the absence of yet another aggravating fact from the defendant's proposed comparators. Fourth, the defendant points to nothing establishing that his proposed comparators even satisfy the elements of the Mann Act. The defendants failed to cite any evidence demonstrating that Spitzer, Faldwell, and the other clients of the escort service transported anyone across state lines for the purposes of commercial X. And there is no indication that Faldwell even paid anyone to engage in X acts. Rather, the article cited in the motion simply suggests that a third person consensually participated in X acts with Faldwell and his spouse. Far afield from the example cited by the defendant, a similarly situated individual to the defendant would be someone who engaged in violence and coercion as part of a pattern of racketeering activity and who transported not only escorts but also victims of that violence and coercion. Because the defendant's alleged criminal conduct is considerably more serious than anything he accuses these individuals of, he has failed to identify any similarly situated individuals who are not charged. This is fatal to his claim. Ah, tomorrow needs to hurry up and come. Moreover, the defendant's allegations against the identified individuals lack evidentiary support as they are based entirely on his interpretations of public reporting. Such hearsay and, ooh, I think, anecdotal evidence are insufficient to meet a defendant's burden even to obtain discovery on a selective prosecution claim. The defendant cannot meet his burden on a selective prosecution claim merely by making unsupported allegations about a handful of individuals and claiming that they should have been prosecuted too. I tell y'all time and time and time and time again, tangible evidence, tangible evidence, something that we can go back and reference and read, preferably a court case. Y'all didn't cite no court cases of any individuals that were similar to what Diddy has done that have been, not prosecuted. We're not going off of hearsay. We're going off of tangible. I've told y'all a lot of times that judges do not go off of hearsay. I heard it with my own two ears in a courtroom in a family law case. They want tangible evidence. I don't care if it's a family law case, a personal injury case, an essay case, a criminal case. Courts want tangible evidence. Those shortcomings defeat the motion, but it also bears noting that the motion does not argue that the entire indictment is selective, only that the inclusion of count three is so. A similarly situated individual would thus be one who is also charged with racketeering, conspiracy, and ex trafficking, but for whom prosecutors declined to charge the Mann Act. The defendant can cite to none. Indeed, there are several recent cases from this district alone in which the government charged defendants of varying races with the Mann Act in addition to ex trafficking, including the prosecution of wealthy fashion executive Peter Nygaard, who is a white defendant who was charged in the district with racketeering, conspiracy, ex trafficking, and Mann Act violations. They put this right here, United States versus Nygaard. They also put United States versus Maxwell. In that, it says charging white defendant with ex trafficking and Mann Act violations. They also cited United States versus Romero Granadas, where it says that they are charging multiple, or that they have charged multiple Hispanic defendants with ex trafficking and Mann Act violations. This is consistent with numerous other indictments returning in this district charging Mann Act violations together with ex trafficking charges. Look at all of these. This right here, do y'all see this? United States versus Rivera, United States versus Purcell, United States versus Pierre Louis, United States versus Ramos, United States versus Paduch, United States versus Haddon. How come Mark Agnifilio didn't cite these cases? The government says these examples demonstrate that prosecutors in this district routinely charge the Mann Act when aggravating factors, including trafficking and other exploitation, are present. If anything, the defendant's case presents uniquely serious aggravating factors given the extensive violence and abuse in the indictment that violated federal racketeering, trafficking, and forced labor statutes, among others. So that's why, and I think I misspoke in my indictment update. What was updated was the forced labor regarding this. At bottom, contentions that handful of individuals were not criminally charged out of the millions of individuals who reside in or otherwise subject to potential prosecution in the Southern District of New York are plainly inadequate to meet the requisite threshold to demonstrate discriminatory effect because they just gave you a whole bunch of cases that are in the Southern District of New York where these individuals, white, Hispanic, are being charged under the Mann Act. The defendant fails to cite even a single case in which a court has ordered discovery on selective prosecution claims based on such tenuous allegations, and the government is unaware of none. The lack of precedent supporting the defendant's position is not surprising, as any such finding would defy the strong presumption that prosecutorial decisions are proper by allowing the exception to swallow the rule. The defendant has failed to offer any evidence whatsoever of a similarly situated individual to demonstrate discriminatory effect, and this motion should be denied on the basis alone. He fails to also show the purpose, the discriminatory purpose. Because the defendant fails to make an evidentiary showing in support of the first required prong, the motion must be denied. But even if the court were to assume, arguendo, that the defendant has made such a showing, his motion still fails on the second prong because the defendant cannot present any credible evidence that would suggest, let alone establish, that the charge of count three resulted from a discriminatory purpose. The second required prong in the discriminatory purpose, meaning the defendant must have been selected for prosecution based on such impermissible considerations of race, religion, or the desire to prevent his exercise of constitutional rights. To prevail, to have this claim move forward, Diddy has to show more than just discriminatory conduct generally. He also has to demonstrate that the government in his case acted with discriminatory purpose. While the defendant slings accusations of racism throughout his motion, he identifies no actual evidence. Indeed, apart from speculation and conclusory assertions, the defendant cites no evidence to make that showing. Nor could he because race played absolutely no role in the decision to charge the defendant. I mean, I don't have to read on because, like they said, he has no evidence. He has no evidence. First, he offers nothing more than his say so that the prosecutors have leaked anything at all to the press. The motion fails to identify the supposed leaks, provides no evidence that any such leaks came from the prosecutors in this case, and offers no explanation of how any supposed leaks reflect discriminatory purposes in charging count three. Indeed, the defendant was previously denied relief in connection with such purported leaks by this very court. Second, the defendant complains that he was not permitted to surrender and was instead arrested by federal agents. But the decision not to permit a defendant charged with committing violent crimes, engaging in obstruction, and actually exploiting victims is entirely consistent with the practice of the United States Attorney Office in other cases, and again does not provide any basis to infer racial animus with respect to count three. Indeed, that decision was tactically approved by three different judges in this district, denying the defendant's repeated bail applications and finding that he posed a danger to the community. Third, the defendant repeats his prior complaints about the manner in which search warrants were executed at his homes. The argument ignores that the warrants were executed not by the prosecutors in this case, but by law enforcement agents who are not the subject of selective prosecution claims. Setting aside that the use of force to secure a premises, especially when the crimes under investigation include violence, I think people are forgetting this part. And the items to be seized include firearms, is entirely justified. It certainly does not demonstrate discriminatory purpose when electing to charge count three. Unsurprisingly, the defendant cites not a single case to support his suggestion that the vague accusations he makes are sufficient to show discriminatory purpose. Further undercutting his position, courts routinely reject speculative selective prosecution claims like the one raised in the motion. The defendant unsupported accusation of discriminatory purpose by the prosecutors handling this case is simply a desperate attempt to shift the focus away from his own criminal conduct. The defendant's own violent and abusive crimes resulted in this prosecution. Nothing more, and I'm going to add nothing less. In sum, the defendant has failed to adequately allege that there was anything unusual, let alone improper, about the charging decisions in this case. Because his allegations fall short of the rigorous showing necessary to make out a prima facie case warranting the disclosure of discovery, much less the clear and convincing standard required for dismissal of count 3 for the selective prosecution, his motion should be denied. In conclusion, the defendant's motion to dismiss count 3 should be denied. I cannot agree. In, any, I agree. I totally agree. Diddy has shown nothing. He has not provided any tangible evidence that the government, the prosecution, charged him with count 3 because of his skin color. Excuse me, sorry. He just can't. Mark Agnifilio, I don't know what he was thinking, but that motion to dismiss just count 3, one is suspicious. But I feel that Diddy is the one that is making them. I mean, again, he hired them. They technically, have to do what they don't have to do what Diddy says, but this is his case. And if he says, "Man, you need to pull all the tricks out the bag that you can," that is what Mark Agnifilio is doing. But for him to file this motion to dismiss only one of these counts and not the other two counts doesn't make any sense. I know Mark Agnifilio is smarter than this. Heck, his own wife is Luigi's attorney. So I know that they're very, very intelligent. I just don't understand why they would thought pulling the race card was going to be something. They cited the government, the prosecution cited cases showing other individuals being charged under the Mann Act. But the difference, what sets aside Diddy from those individuals, is that his has violence. He has a history of obstruction. I don't think that there are any other people. I mean, there probably are, but as of right now in the courts, there are no cases that are similar. That's why they couldn't cite them. Y'all let me know what y'all think about this in the comment below. What do y'all think is going to happen tomorrow? Because they are discussing that motion to dismiss count 3. What do you think is going to happen? How do you think the judge is going to rule? Put it in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.